Hello friends, in the series on the income tax cases, today we will discuss the case of India Institute of Banking and Finance versus Commissioner of Income Tax Exemptions. This case has been reported in 107 ITR Tribunal at page number 250. The matter has been decided by Mumbai ITAT C bench and the date of the judgment is 17th May 2023. As all we know, after the decision of the Honorable Supreme Court in the case of New Noble Education Society and Chief Commissioner of Income Tax, which is decided in 2022 and which has been reported in 448 ITR at page number 594, the courts and the department is very strict in granting the exemption under section 1023C clause 6 only because of the word used in the section 1023C clause 6, that is solely. The word solely has been defined in that case very precisely. Solely means nothing other than education, meaning thereby that now the exemption under section 1023C clause 6 will be allowed only to those assessees which are at the face exist only for the purposes of education. If they earn any income which is not related to the education, that organizations will not be granted exemption under section 1023C clause 6. For example, in this case, the formation of the assessee was done with the objective of educating the various persons which are involved in the banking sector, preparing material for the education of the employees of the banking sector, providing various seminars, conducting various seminars, and also preparing the various materials for the purpose of the education of the banking. And this material was also published by the assessee by giving the copyright, and when this material was published, that material was sold in the market for earning the royalty also. So the question before the department was that whether the assessee can be granted exemption under section 1023C clause 6. Obviously the department denied. That is why the matter was before the ITAT. ITAT said that giving the copyright for publishing the material and then earning royalty from that cannot come into the definition of the education. The ITAT said that there is word existing before solely in section 1023C clause 6, which says that, and which can be interpreted in a way that the condition for earning the income from education is not only for the year for which the matter is under consideration. For example, if in any year it is proved that the institution is not there for the education solely, then the exemption under section 1023C clause 6 can be withdrawn. The ITAT tried to give a distinction between the exemption under section 10A, 10B, 80IB and section 1023C clause 6 because the court said that in those sections, once the assessee fulfills the conditions, then those conditions are not tested every year, but the assessee has to satisfy this condition every year. In this case, section 1023C clause 6 conditions were also discussed. The exemption is given only when the assessee is a university or educational institution. It exists solely for the purpose of education and there should not be element of profit. Element of profit means that the profit should not be very exorbitant. Normal profit 5 to 6% can be there, but there is no yardstick for that. The educational institution should be approved by the prescribed authority. So friends, from this case it is clear that if any educational institution will divert from its objectives and try to earn income from any source which is not very much directly related to the education, there is every possibility that it can lose the exemption under section 1023C clause 6. At the end of this video, once again I am repeating the name of the case. The name of the case is India Institute of Banking and Finance versus Commissioner of Income Tax Exemptions, and this case has been reported in 107 ITR Tribunal, page number 250. The matter has been decided by Mumbai ITAT C bench and the date of the judgment is 17th May 2023. Thank you, friends.